I want to just introduce it very quickly, is Florida v. Frank Bybee. Bybee is a former Sarasota County Sheriff's deputy who's been charged with, get this, 18 felonies, including attempted murder, exploitation of the elderly, burglary, theft, and kidnapping. This is a very strange story that involves an attempted murder of a 79-year-old woman. He faces a life sentence if he's actually convicted of that first-degree felony of attempted murder. I'm going to go into a little bit more detail of that later on if we're able to cover it. But in the meantime, we're going to have two special segments that we have to talk about this morning because we have a great guest to talk about it. The first case that we're going to be talking about is Taylor Swift. Songwriters Sean Hall and Nathan Butler have filed a suit against Taylor Swift for a lyric similarity. Hall and Butler claim that Swift's song Shake It Off, which I'm sure many of you know and love, bears a close resemblance to their 2001 hit Players Gonna Play. That's performed by the group 3LW. The suit targets Swift and her co-writers Max Martin and Shellback, as well as Sony ATV and Universal Music Group. They're asking for 20% of Shake It Off songwriting credit and all pertinent royalties. That's a lot. Now, the songs don't sound at all alike, which you usually see in a copyright infringement claim. Here, the disagreement stems from the phrase, "the play is gonna play, them haters gonna hate," which are the lyrics in the chorus in Hall and Butler's song. The writers claim that Swift copied that phrase with her lyrics because the player's gonna play, 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 and the hater's gonna hate, 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 hate. Excuse me, I'm not a singer. You'll have to imagine what it sounds like. But the question is there a justifiable copyright infringement claim here? That is the question. So to help us talk a little bit more about this, as well as the next case we're going to talk about, we have with us business and entertainment attorney Seth Berenzweig. Seth, it's great to see you. Thank you for joining us here on the LawNewz Network.
My pleasure. Thanks for having me.
So let's talk a little bit about this case and to give a brief background for our viewers about copyright infringement in general. How would someone in general sue someone for copyright infringement of a song?
Well, the allegation in a case like this is that there has been some type of intellectual plagiarism that either as a result of the lyric side of the composition or on the underlying music that supports the lyrics, or perhaps both, that was plagiarized and stolen as somebody else's idea versus the musician or the artist having it as their own conception or composition.
Yeah, that makes sense, but here we're dealing with some lyrics. There's a question out there whether or not just a few lyrics is enough. Can short phrases like that be subject to copyright protection?
Potentially, but here probably not. There was a case that was very similar to this regarding the same song and the same words at issue in a case that was filed a couple of years ago in federal court in California. And in that case, that was filed by an R&B singer, Jesse Graham, who records as Jesse Graham. He also filed essentially the same lawsuit, claiming that this was a phrase that was really put into play because of his creation. However, that case was immediately dismissed, and the judge in that case said that these kinds of short, common phrases are not copyrightable.
So what would be a situation where you might have protection for their short phrases? One of the arguments that they're making in this case is that these are original lyrics, that back in 2001, that phrase, players gonna play, haters gonna hate, that phrase was something that really wasn't in our nomenclature, our popular culture at the time. Now we know it very well. Is that an argument that if it's very original, even if it's a short phrase, it might be subject to copyright protection?
It's possible, and it could be. I think that's going to be a real uphill battle in this case, but it is possible. So let's say, for example, and we're just going to create something for the sake of argument, that someone wants to say in a song that it's been a hard day's night or something of that nature. I think that you would have a little bit of a better argument that there was some kind of original creativity that would surround a kind of a picket fence of intellectual property around that. But when you're talking about players are going to play and haters are going to hate, One of the fact issues involved in the case is whether that's really an intellectual original creation or really just kind of a common parlance in pop culture. So I think that might be a disputed issue in the case, but that's going to be a really uphill battle. And I think that Taylor Swift has a little bit of the better argument teeing it up in that litigation.
I agree with you. I think she's going to probably be able to shake this off as she did the other lawsuit. But I do want to play devil's advocate here and play a little bit with this idea. When you have a copyright infringement suit, there's many questions that come into play. Correct me if I'm wrong. You have questions of access, whether the plaintiff, the defendant, had access to that work beforehand. Were they able to see it? Were they able to hear it? Did they have access to it? And then the question becomes, are the two works substantially similar? But here you're saying the first barrier for the plaintiffs in this case is to say that even what they have is original expression, original work, that they even have a copyright in it in the first place. So you're saying once they get past that hurdle, then they'd have to get into the other issues of substantial similarity and access, correct?
That's exactly right. And I think that you raise an excellent additional point, which is reminiscent of a very related and important case. The question of access and how it plugs into the copyright and the plagiarism allegation is something that's always a big ingredient in these cases. So let's go back just a couple of months ago to the Led Zeppelin case on the litigation regarding Stairway to Heaven. The issue that you just identified was recognized as an important issue in that case. That really pops up in a lot of these cases because the question became whether Led Zeppelin had access to that song that even would have given them a chance to violate a copyright to begin with. And in that case, it was alleged that the reason why they were aware of it was because they were an opening act for Led Zeppelin tourists going in, and that therefore Jimmy Page was able to grab onto that and then move forward for their own purposes and have a copyright violation. So those kinds of issues that you've identified also bleeds into these kinds of cases, and as you've probably seen on the horizon, these are becoming even more prevalent.
Yeah, and I'm curious, just because an artist puts something out there, now I'm going to be the first to say it, I am not familiar with 3LW. I'm not familiar with this song, but they seem to be a big group back in the day. They put out this song. I've looked on YouTube. It has many views. Is that enough to show that Taylor Swift, I'm talking even if they can show, okay, they have some sort of protection over this phrase, over these lyrics, is that enough to show, hey, Taylor Swift, it's very easy, she might have heard this?
I think that is an ingredient that goes into the case, and I think you've identified one of the segments of what they're going to argue on this issue of access. And this is where these cases become pretty complicated. But I think that the complicating factor even further still for this case is that you are talking about a short phrase that could be of common parlance, and the federal judge in the Central District of California, in dismissing the first case for the Shake It Off litigation, said that that was really the core problem, that it was something that got thrown out immediately on a motion to dismiss. The judge wasn't even willing to dig even further on that. That's going to be some precedent that will weigh heavily here.
Seth, I agree with you, and I can't talk about this case without really getting to the elephant in the room, the blurred lines verdict. I mean, this has really changed, I believe, the landscape of copyright law, musical compositions, whether or not things are copied. Just to give our viewers a little bit of background, Marvin Gaye's family emerged victorious back in 2015 in a case involving a song called Blurred Lines by Robin Thicke, Pharrell Williams, and T.I. Hugely popular, way popular, but it was decided that that infringed Marvin Gaye's Gotta Give It Up. The verdict has actually been appealed to the Ninth Circuit. I believe oral arguments are going to be heard on October 6th. A court judge awarded $5.4 million in damages and 50% of future song royalties to the Gaye family. The decision has been widely criticized. Before we get into what the future of that decision is and the nitty-gritty of that suit, has that just changed the landscape where you see more kinds of lawsuits coming forward like we see right now with Taylor Swift?
Absolutely. That was a case that is one of the most critical and I would argue shocking cases in music copyright litigation in the country right now. I think that you've really hit it on the head. That's one of the most surprising and controversial verdicts that's come down the pike. That's continuing to charge more litigation. That hearing on appeal is going to be critical because there were other issues that are similar to what we're talking about here, quite similar. Although it had a little bit less to do with lyrics and more in terms of comparability of the underlying style of the composition, where that was a very surprising verdict that's going to be very hotly contested on appeal. And that ruling that's going to be not far down the road is going to have a major impact not only on copyright law, but really on the music industry as a whole. So you're talking about an area of the law in entertainment that's really growing and is going to continue to have a very significant impact.
I agree with you because, look, we artists take inspiration from where they can find it. And there's a difference between copying and there's a difference between inspiration. And this case, in the decision, it was that they had the same feel or groove. Now, I don't know necessarily what that means, and I don't know what that means for artists moving forward, how they're going to be able to create original content when everything, you're only granted a certain amount of lyrical notes, a certain amount of ways to create a composition, way to create a song. This is going to have a tremendous chilling effect. When you look at a decision like that, does that make sense, the feel and groove?
I was completely shocked by that verdict, and I really believe that that's going to get overturned. If it doesn't get overturned, that's going to have a huge impact, and frankly, I think it's going to turn the law upside down. So I agree with you. I was very surprised by that, having the same feel and groove. I think that really might relate to the type of genre that you've been influenced in. But if that's going to be the new standard, then it's really going to, no pun intended, rock the music industry. That was a very shocking result that has major reverberations, and that ruling not far down the road is going to have a very critical impact for artists coast to coast.
I agree with you. It's little tough to swallow. It's tough to see because not only will you say it has a chilling effect on future recordings and future songs being created, but you're going to see all these lawsuits coming out. Everybody's suing everybody for, oh, you took this of mine, you took this of mine. But I do want to talk to you a little bit about one final aspect of the Blurred Lines appeal. One of the issues is that the original Copyright Act, okay, of 1909, it based the copyrights, the argument is on, there was no sound recordings, it was on sheet music. So the argument that's being made, and correct me if I'm wrong, is that it's unfair to judge the recordings of Blurred Lines and Gotta Get It On be based on the sound recordings, because that's not really what the act was intended when Marvin Gaye created his song. You got to base it on the sheet music. Look at the sheet music side-by-side comparison, and you'll see there's no substantial similarity. Is there merit in that argument?
I think there is merit in that argument. There are counter-arguments that flow both ways, but I think that that is a very legitimate argument because there's really no other, let's put it this way, I don't think that you can ignore that as a recognized method of gauging a determination of the comparability of those pieces. And what you really need in litigation like that typically is to have an expert witness who understands sheet music to look at them and provide a detailed explanation of how they're similar or different. And that was really something that I think the defendants could have done a little bit of a better job in that litigation. But yes, I think you've identified something that is a cornerstone of how to defend these kinds of cases and something that's going to be relevant when we go into that critical appeal.
Well, we're going to have to see how it goes, and as soon as we do have some sort of impact, understanding of what that appeal will be, when we have some news on that, I would love to have you back to talk about that. But in the meantime, while we do have you, there is another case that I do want to talk about. We also want to talk about here on LawNewz about Tom Cruise. Mega superstar Tom Cruise has been cited in court documents as partially at fault for the death of 2 pilots and serious injuries to a 3rd pilot on the set of his most recent film, American Made. Alan Perwin and Carlos Burl died in a plane crash in September of 2015 during production of the film, while Jimmy Lee Garland no longer has feeling in his lower body. And in a lawsuit that was brought against the producers of the film, Imagine Entertainment, Vendidian Entertainment, and Cross Creek Pictures, the family of Perwin and Burl claim that Cruise and director Doug Liman's negligence resulted in the crash. And what they said was, in the suit, Lyman and Cruise wanted a high-risk, action-packed motion picture which contributed to the circumstances that led to the crash. The demands of filming in Colombia, together with Cruise's and director Doug Liman's enthusiasm for multiple takes of lavish flying sequences, added hours to every filming day and added days to the schedule. And then in targeting the production companies, the complaint says that there were lapses in planning, coordinating, scheduling, flight safety. It was the defendant's responsibility, and they put out an unprepared, unqualified pilot, and there's so much to talk about in this case. So, Seth, the first thing I want to just ask from the very beginning is, against the production companies, do the families of the victims here, do they have a strong wrongful death case, and also against the production companies?
I think that they do. In the first case we chatted about, that seemed to be potentially a weak case. Turning the corner on this case regarding Tom Cruise, although he's not listed as a defendant, this case seems to be fairly strong. Very tragic circumstances, as you've very accurately pointed out. It's the legal responsibility of the production companies to ensure reasonable steps taken to ensure safety for the production. And it appears that although they'll have to really dig into the facts and see ultimately how the evidence weighs in trial, it seems to be a case that has merit. It is interesting how they're teeing up Tom Cruise in the description here. He's being described, along with the director, as someone who has some kind of a negligence-based blame on this for kind of pushing the envelope on safety and demands. He's not a named defendant. So what they're doing, the plaintiffs are doing, is they're using that as an ingredient to upflow liability to the production companies. And perhaps that's the reason why Tom Cruise has been very low-key in actually publicly forwarding out and having advertising for this movie, because the last thing he wants are a bunch of straight questions thrown at him that could drag him into this lawsuit beyond the scope of where he is right now.
Why do you think he wasn't named in a defender, or hasn't been named as of yet? I mean, couldn't you name them as a co-defendant? It was the production company's fault, but it was also Cruise and Lyman, who, their negligence, they were the reason, they were the cause for why they had to film in these conditions.
So interesting that he's not named as a defendant. I agree. Usually in a case with these facts, you would see the star with these kinds of allegations brought in as a defendant. And reading between the lines, I think that one reason why is because when you're on the plaintiff's side in complex litigation, suing more than a handful of defendants can raise a lot of complexity and cost in being able to tee up your burden of proof. They already have 3 defendants in this case, as you've mentioned. And if they can take the negligence, the alleged negligence of Cruise, and just roll it upstream as something that falls on the shoulders of the production companies, then they can use the allegation of his negligence that created an unsafe work environment and really just kind of land it at the doorstep of the producers without having to go through the complexity of facing another defense firm. So I think it was an interesting strategic decision, but the overall composition of the facts indicate that there are serious allegations against Tom Cruise.
Is it also the idea that if you are just suing everybody, you're just suing everybody that might have had some impact on this tragic event, it kind of loses your credibility in a way? You lose a little bit of that fight?
Absolutely, and I think that this indicates that there's some level of sophistication of the plaintiff's counsel in this case. It becomes very dilutive. It's hard to go into a jury trial with multiple extensive defendants that are sitting in front of them trying to sort out the issues, trying to sort out the documents. And if you do try to drag in a star, I think that that could raise some credibility issues too. So I do agree with that.
What about the fact that Cruise, this has been mentioned in this lawsuit, he does his own stunts, everyone knows this. He's an experienced pilot, but he didn't fly that plane when he could have. Is there any merit to that argument in this lawsuit?
Yeah, I would say yes. That is an interesting point. If this was something that had a reasonable degree of safety, and he is a trained and experienced pilot, then why didn't he fly? And I suspect that one of the reasonable
Seth?
I think it was safe.
Yeah.
Yeah.
Oh, sorry, I think we lost you for a second.
Oh, yeah, that he didn't think it was safe.
Yeah.
So that would be an indication of what would be supportive of the allegations, because they're saying that it was unknown terrain, it was bad weather, they were making sharp turns. So I think that that'll be a factor that'll play out in the trial.
You know, just to provide our viewers with a little bit more context, when you're reading about this lawsuit, an executive producer sent a formal complaint to the insurance company, and we're going to talk about that insurance company in a minute. They complaining about Cruise and Lyman. He said the director, Doug Lyman and Tom Cruise, added entire scenes and aerial shots on the fly. They had to bring in Unisafety to help wrangle them. In the last 48 hours, this has become the most insane stuff I've dealt with. And then in a separate email, Perwin, who's one of the victims here, he called the film the most dangerous project I've ever encountered. You have no idea the exposure Tom Cruise and the entire aerial team is realizing every time we get in the air. There's a very thin line between keeping all aerial activity safe and having an accident. Trust me on this. Now, these have come out in the last few days, and as you said, Tom Cruise is being very low-key with this movie and promoting it on the media circuit. Whether or not he's implicated in this lawsuit, whether or not he's actually named as a defendant, but he is implicated in this lawsuit, keeping a low profile when all of this is coming out, this material, Seth, you'd have to imagine that's a smart move, a strategic move. What do you make of that?
Absolutely, and I think that what he and his people are doing is making sure that they're not going to be in an uncontrolled media environment where there are questions that are going to be lobbed at him, because if he takes a swing at a question and misses, then he is at legal jeopardy. You've also pointed out one of the really compelling and unique factors of this case. It's unusual in a wrongful death case to have a writing, an email from one of the decedents that literally says that this is, quote, one of the most dangerous projects that I've ever encountered.
Right.
And really laying out in detail the circumstances. So that really weighs to the elements of proof in the case.
Yeah, it's not good for the defendants. But there is one thing. There's one avenue that adds a little bit of complexity to it. The pilots, the families, are blaming one another. It's not even entirely clear who was flying the plane. You have separate lawsuits where the plaintiffs are blaming each other. This person was flying, this person was flying, this person was unqualified, this person was unqualified. They're going into background histories of each one of these pilots. The idea that everyone's blaming one another, does that add a sense of complexity to their case and maybe can damage them?
It does, and I think it helps the defendants, because the defendants will say that these are plaintiffs that, albeit in a horrible family tragedy, are really looking to cast blame on somebody, and they're even pointing fingers at each other. So I think that that's going to be a logistical advantage and a benefit for the defendants. If I was plaintiff's counsel in this case, I would really just call a conference with the other law firm and sit down and say, guys, we cannot turn this into a finger-pointing exercise. But I think that you've identified something in this case that is going to be one of the headaches that the plaintiffs will have to deal with, and what is otherwise what appears to be a pretty strong case that they have against the production companies.
Yeah, I think, I mean, it's what would you say? You think it's going to settle?
I think ultimately these kinds of cases do tend to more often than not settle, and one of the helpful components of that is that all of these large-scale productions have a fairly significant personal injury insurance policy backing up the production. So that's an ingredient that tips the needle towards a likelihood of settlement. And in a case like this, the judges tend to be pretty persuasive in trying to push them towards a settlement conference before a trial takes place.
Seth, you nailed it right in the head. I want to talk about that insurance company. Great American Insurance Company filed its own lawsuit in federal court against Cross Creek Pictures, Imagine Entertainment, and Vendidian Entertainment, again, the defendants in this case. And Quadrant Pictures, excuse me, and others. The insurer is looking for a declaratory judgment that it doesn't have to provide coverage for the plane crash. They claim that they have no duty to cover this fatal accident because the aircraft transporting crew members was used for an unlawful purpose. The actual language that's used is, it suggests the possibility that at the time of the accident, the aircraft was being used for an unlawful purpose or for a purpose not designated in the declarations of the policy. And such use was with the knowledge and consent of an insured or an executive officer, partner, or managing agent of an insured. Now, again, Great American gets specific by claiming that the aircraft may not have been piloted by a designated individual, nor piloted by someone properly certified, qualified, or properly rated under the law. They're trying to get out of this. Is that, how do you think they would be successful in that? Again, they're insuring a movie project where stunts are part of the project. These things can happen. Isn't this why you have insurance?
Such an interesting issue. And what you just mentioned, I think, is the first comment that the judge is going to say is, this was not driving Miss Daisy.
Yeah.
This was a case where they knew that this was going to involve stunts. It's an interesting and pretty vanilla legal theory. And whenever an insurance carrier is on the hook potentially for a case, they issue what's called a reservation of rights letter, where they come in and they reserve the right to not provide coverage under the policy. I think that's going to be a hard argument for them because the question is whether this was something that was reasonable, foreseeable as conduct that would be covered under the insurance policy. And as you accurately point out, in a case like this where you have stunt flyers, it's going to be difficult for the carrier to say that that wasn't conceived as part of the scope of coverage.
I'm curious moving forward. I'm sure Tom Cruise, I would imagine, feels terrible about what happened. Whether he was, you want to say he was to blame or not, this still happened on a movie set where he was starring in. How do you think this case, we have a lawsuit and in general, we have 2 people that died and 1 who's seriously injured. Do you think this is going to affect how movies are filmed later on, the level of dangerous stunts we see? Tom Cruise always pushes the boundary in each one of his movies, and usually he does his own stunts, but pushing the boundary on movie sets, do you think that this is going to change that in a way?
It should. It should be something that would be a part of the conversation. I believe that in a movie production that was being filmed about a month or a month and a half ago, there was a motorcycle stunt of somebody that was to crash through a glass wall, and that was a stunt that went wrong, and unfortunately that stunt person tragically passed away. There's a very thin line in Hollywood production between people understanding the nature of the risks, or what we would call assumption of the risk, and really crossing that line. That line is pretty gray and pretty controversial, but hopefully tragedy that's posed in a case like this will help highlight that for when productions move forward, that they really need to do everything that they possibly can to avoid loss of life. Because this is big money and big business, but hopefully they'll make sure that they don't go through and cut corners at the risk of actually having somebody else lose their life.
Yeah, I hope so. I hope you're right. I can only imagine, I'm assuming how many times there's so many dangerous stunts that are done in movies, and you could look at a director and maybe the stunt coordinator and some of the production people looking at each other with a sigh of relief after a stunt goes well, because there's some pretty crazy stunts, and there's constant discussion about whether there should be a more switch to CGI as opposed to doing real stunts, and I guess that's a conversation to be had about whether or not CGI is the way to do it. You protect stunt people from actually doing these stunts. Maybe that's the answer. We'll have to see. My final question to you for this case is, you think this is going to hurt the movie's profitability? Are people not going to go to this movie because of this dark cloud that's surrounding it?
Well, there have been market estimates that have predicted that there will be some kind of a tangible, measurable effect because the litigation has caused Tom Cruise to take a half step away from the promotion that ordinarily accompanies this kind of a major production. So through one means or another, it is probably going to have a financial effect on the revenues for the film. I think that it's going to have an effect. And beyond that, it's going to be difficult to tell. That's more art than science. But it is unusual in a case like this to have this kind of litigation in the background where the star is really keeping such a low profile.
Yeah, I know. It's like you said, it's a very interesting move. Could be from a strategic standpoint, or it could also be because he feels guilty in a way. Feels guilty about what happened. I mean, in the end of the day, you have someone. You have two people that died, one who's seriously injured. It puts questions on the movie, puts questions on whether he's to blame. It's a tragic case, but we're going to have to see what happens, and hopefully when we have further analysis and further development in this case, we'll make sure to have you on.
Would be my pleasure.
Thank you so much, Seth. It's been a pleasure having you on, and we really appreciate it, and we'll make sure to have you on when we have other entertainment stories to cover. So thank you so much.
Thanks for having me.
Take care.
Bye-bye.
Bye-bye.